Good morning for everyone, and welcome to this webinar that is organized by the LEF Network Azerbaijan project, and that is funded by Indirect Central Baltic Program. And we are carrying out this webinar together with Stanum International Training and Consulting. And in this project where we are working together with Latvia, Estonia, and Finland, so we are trying to help companies to find new business possibilities in Azerbaijan. And these webinars, these are really good ones and give a real deep insight to Azerbaijan's business possibilities and legal aspects and everything. And so this is the final webinar we will have, and the subject is legal protection of intellectual property in Azerbaijan. And we have expert Mr. Emil Gezalov, who is legal and compliance professional in Azerbaijan. So he will take us through a lot of subjects, and just like we discussed earlier, so this is a big subject. There are a lot of details, and hopefully these webinars will give you ideas, will give you some tools what to take into consideration and what must be done before the business starts. But this webinar will be also recorded. It has already started, and we will share this in our project website. And after the webinar, you can ask questions, and you can also send messages during the presentation. So maybe we can also stop in some point if there are many comments or questions, so we can discuss in those places we are talking about certain subject. But yes, welcome to this webinar, and Emil, the floor is yours.
Thank you very much. If you don't mind, I'll share the presentation. Just a moment. Okay.
Yes, now we can see.
Okay, good. So, dear participants, good morning and welcome to today's webinar. We're delighted to have you with us for this important session dedicated to the legal protection of the intellectual property in Azerbaijan. My name is Emil Gezalov, and I'll be your speaker for this webinar. On behalf of the organizing team, I would like to thank each of you for joining us today. We encourage you to engage actively, ask questions, share your insight during the session, and we hope that your knowledge shared today will be practical value to your professional activity and deepen your understanding of the IP system in our jurisdiction. Once again, thank you for being here, and we look forward to a fruitful and the engaging discussion. Okay. For those of you who are joining us for the first time and did not attend the previous webinar, I would like to briefly introduce myself. I have more than 20 years experience in legal and compliance, and being head of legal department in the Ministry of Defense and Industry, I'm also a legal counsel at the Azerbaijani Bar Association, and I have a long-term experience as in-house legal in the big holdings in Azerbaijan, and I was a senior legal advisor in one of the Big Four consulting company, and I'm engaged Stanum International Training and Consulting as a legal and compliance expert. The Standard International Training Consulting is a globally recognized leader of professional training and consulting, which is approved by the British Chartered Institute of Procurement and Supply and the strategic partner of the British Chartered Institute of Logistics and Transport. Okay, sorry, pardon. The protection and enforcement of intellectual property rights is a cornerstone of the modern innovation and business strategy. Today's webinar aims to shed light on the legal framework and practical procedures and professional support available in Azerbaijan. Okay. Intellectual property refers to the result of human creative and intellectual activity that are subject of legal protection. In today's world, IP has become a vital asset not only for individual creators, but also for business, science, and technology. In Azerbaijan, the intellectual property rights system has been actively developing since the country gained independence. Over the past decades, the legal and industrial foundations for the protection of copyrights, patents, trademarks, and other IP assets have been established. Azerbaijan's legislation has been harmonized with international standards, and the country is a party to key international treaties in the field of the IP. This creates a legal environment favorable for both domestic and foreign rights holders. Understanding the fundamentals of the IP is essential for the safeguard innovation, building competitive business models, and attracting investment. In this presentation, we will examine the main categories of IP, the legal mechanism of their protection, and special regulatory framework in Azerbaijan. So, intellectual property encompasses intangible assets created through the intellectual effort. There are several main types of IP rights, each protecting different forms of creativity and innovation. Trademarks, protections of logos, names, symbols, and other identifiers. Patents, protection for new inventions, innovations that provides a new way of solving a problem or doing something. Copyrights, protection of literature, artistic, or and musical and other works. And the last one is the commercial secrets, protection of confidential business information like formulas, practice, or processes that provide competitive advantage. So let's talk about separately about the trademarks. And trademarks is any combination of graphically represented signs that distinguish the goods or services of one entrepreneur from those of another. Trademarks may include words, personal names, letters, numbers, figurative elements, the shapes or packings of goods, any combination of colors, or any combination of the above. Warning symbols, very important. The holder of trademark certificate may use warning symbols alongside the trademark to indicate its registration in the Azerbaijan Republic. Not only Azerbaijan Republic, but this symbol defined the how to say registration of the trademark in all the world, not only in Azerbaijan. The next object is a patent. Patents a tool of protection for new inventions and innovations to provide a new way of solving problem or doing something. So patent protects the rights of owners to the following intangible assets: its invention, utility model, and industrial design. Invention. An invention is a technical solution related to the product or process in any field of technology. To qualify the legal protection and invention must be the following criteria. First of them, novelty. Novelty is the invention must not form part of the prior art. That is information that has become publicly available anywhere in the world before the filing date. Disclosure of the invention by the inventor, applicant, or someone who obtains the information from them directly or indirectly does not affect novelty, provided the application is filed with the competent authority within 12 months of the disclosure date. The burden of proof in this case lies on with the applicant. Inventive step, the invention must not be avails to person skilled in the relevant field based on the existing knowledge. And the third criteria is industrial applicability. It's very important because the invention must be capable of being manufactured or used in any industry or field of economic activity. So the following IP object shall not be considered as invention. You can see on the slide such objects. It says discoveries, scientific theories, mathematical methods, result of aesthetic of design activity, method of organization or management, game rules and methods, algorithms and computer programs, methods of presenting information, symbols, schedules and rules, layout and plans for the structures or buildings, plant and animals, except the microorganisms, and essentially biological methods of breeding, topographies of integrated circuits, surgeon therapeutic and diagnostic methods applied to other human and animals. This subject maybe not there was not a subject of IP of patents, but it's a subject of copyrights maybe. The utility model is a technical solution related to the device. Legal protection of unity models applies a similar criteria as the inventions, novelty, and industrial applicability. Not considered unity models, it's a solutions concerning the appearance of the product intended solely to meet aesthetic needs and topography integrated circuits. And regarding the industrial design, an industrial design is a creative solution determining the appearance of the product. It may consist of the drawing, a model, or combination of both. Legal protection is granted if the design is new or original. The design's essential features such as shape, configuration, ornamentation, or color scheme must not be known from prior art as a priority date. Prior art includes any publicly available information and registered trademarks related to the design in Azerbaijan. And disclosure exceptions regarding this disclosure of the design by author, applicant of person who obtains the information from them does not affect novelty if the application is filled within 6 months of the disclosure date. The applicant must prove these exceptions. And originality is a design must be reflected to create character in aesthetic aspects of the product. Not considered industrial design is a design of dictated solely by the technical functions. Architectural objects expect a small architectural form. Industrial, hydraulic, and other stationary structures. Printed matters, object of the unstable form made from the liquids, gases, powders, and small substance. Okay, let's talk about the patent protection. So industrial utility models and industrial design are protected by the patents which confirm authorship and priority, grant exclusive rights to use the protected object, and are used by the issued by the competent state authority. We have some limitations. The patents are not granted and protected is denied for the inventions, utility models, or industrial designs whose commercial use would contradict the public interests, humanitarian principles, and morality, and will cause significant harm to health, safety, animal, plants, and or environment. The copyrights apply to works of science, literature, and the arts that are the result of creative activity. These works may be published or unpublished, but must exist in some object form, regardless of their purposes, merit, content, or the method and the form of their expression. Registration is not required for this acquisition or exercise of copyright. Copyright protects a right automatically upon the creation of the work. However, I recommend to apply to the relevant registration authority to have a copyright formally recognized in order to avoid potential disputes where it may become difficult to prove that you are the legitimate and acknowledged author. Sorry. The form of expression protected copyright. Works protected by the copyright may exist in various objective form, including written in the form of typed text, manuscripts, and etc., verbal or oral, public speeches, performances, audio or video recordings, mechanical, magnetic, digital options, optical, visual. It's maybe like drawings, sketches, painting, plans, film frames, and etc. And dimensional sculptures, models, structures, etc., and other form of such objects. Part of works such as a title of charter and other elements may also be protected by the copyright if they meet the criteria established in the law and can exist independently. Copyright does not protect ideas, process methods of development, or mathematical concepts. Protection applies to the form of expression, not the underlying idea. Ownership of the physical object containing a work does not include the copyright to the work itself. transfer of the ownership and possession of the physical object does not transfer the copyright unless this specifically provided by law. So, with the object of the copyright protection includes the literary works, dramatic and musical dramatic works, choreographic works and pantomimes, music works, audiovisual works, work of fine art, handmade works, architectural works, photographic, map and plans, sketches and illustrations, derivative works, and others. The computer program are not protected as literature works, including all type of programs, for example, operating systems, regardless of the language of the form used, including the both of source code or object code. Advertisement may also qualify as a copyright protection if they meet the criteria set out by the law. But what not protected by the copyright? The official documents, for example, laws, court decisions, legal texts of legislative, administrative or judicial nature, and other official translations, their translations. State symbols and emblems, flag, coats of arms, orders, currency, and other official signs and symbols. It's not protected, are not protected by the copyright. The next one, the folklore and traditional cultural expressions. And the last one is the news of the day and information reported on the various events and facts of the purely information nature. Sorry. Under the legislation, local legislation, a commercial secret is defined as information related to the production, technological, managerial, financial, and other activities of legal entities and individuals, the unauthorized disclosure of which may cause a damage to the legitimate interest of the owner. We talk about the commercial secrets later, more detailed. And the next one, interesting and very important in the modern life, object is a know-how. As a know-how is an important object of the both intellectual property and trade secret protection. And know-how refers to the information resulting from the intellectual activity that qualifies as a trade secret and which is not protected by the patent, either as under the law or by the owner's decision. Okay, let's talk about the legal frameworks of the intellectual property protection in Azerbaijan. The protection of intellectual property in Azerbaijan is governed by by a set of legislative acts that established the rights, registration procedures, and enforcement mechanisms for various IP objects. The key legal instruments include the Civil Code. The Civil Code lays down the general provision regarding the recognition and protection of intellectual property rights, including the ownership, licensing, and enforcement mechanism for the IP assets. The next one is the law of Azerbaijan Republic on trademarks and geographical indication. This law regulates legal relations connected to the registration, protection, and use of the trademarks and geographical indication. It defines the scope of rights granted to the trademark holders and outlines procedures for enforcement and dispute resolution. The third one is a law of the Azerbaijan Republic on patents. This law governs the property and related personal non-property rights arising from the creation and legal protection and use of invention, utility models, and industrial design. It's establish the criteria of patentability and procedures of obtaining the patent. The next one, the law of the Republic of Azerbaijan on copyrights and related rights. This law regulates legal relations in Azerbaijan relating to the creation and use of work of science, literature, and art, as well as the performance, phonograms, and broadcasts, and other. It set out the right of authors and performers and the term of protection. And the last one is the law of Republic of Azerbaijan on trade secret or commercial confidentiality. This law governs legal regulations concerning the protection of the trade secrets, including the criteria for the classification as a trade secret, obligations of confidentiality, and remedies for unauthorized disclosure for use. So let's talk about the international treaties. The Azerbaijan is committed to ensuring effective legal protection of the intellectual property, not only in the national level, but also through the active participation in key international agreements and cooperation with the international organizations. Many provisions of international treaties have been incorporated into national legislation, including the law of copyright and related rights, and law of patents and civil code. Azerbaijan provides a national treatment to foreign right holders, ensuring the equal protection under the domestic law. Code and enforcement bodies consider international legal norm when adjudicating and IP rights, especially in cross-border infringement case. Azerbaijan has actively integrated into the international system of IP protection. Participation in global treaties and implementation of their provisions into the domestic legislation, as I said before, allow both of local and foreign IP holders to effectively enforce their rights within and beyond the territory of Azerbaijan. This integration would not be possible without the country's recognition and accession to key international legal instruments. So in this slide, you will find the list of major international legal instruments to which Azerbaijan is a party. These instruments guarantee, define, and standardize the global framework for IP protection. The main important convention is a WIPO convention. It covers all areas of IP, and it's about the participation in the global IP system, access to the WIPO programs. The next one is the Paris Convention, dated in the 25 February 1995. It covers the industrial property, patents, trademarks, and designs, and it regulates the national treatment and rights of priorities for the applications. Berne Convention is about the copyrights, and it regulates the automatic protection. It defines the automatic protection of creative works without registration. Madrid system, it's about the international trademark registration. It regulated the one application. It defines the one application enables protection in the multiple countries. The next one is the Patent Cooperation Treaty. As we've seen in your names, the patent is regarding the patents, and it simplified the filling of the patents implication in the multiple countries. The next one is Patent Law Treaty. It's about the simplification of the procedures for filling and maintaining the patents. NDAs agreement provides the classification of the goods and services for the trademark. It's the use. It defines the use of the unified international classification. It consists of the approximately 45 classes. And the last two agreements is a Lisbon Agreement about the protection geographical indication and at the international level, and Hague Agreement. It's about the registration of design in multiple countries via this single application. Okay, I'd like to touch the topic regarding the local administrative bodies, which is related to the IP object protection. So the Intellectual Property Agency of Azerbaijan, of Republic of Azerbaijan, is a central executive authority responsible for the state policy and regulation in the field of the intellectual property in the country. Intellectual Property Agency of the Azerbaijan Republic has been established according to the order of the President of the Azerbaijan Republic on the measures and to approve management in the field of consumptions, market control, standardization, metrology, and protection of intellectual property rights. So through the reorganization, corporate agency, and the Patent and Trademark Center in a form of merger. This body is a centralized organ, state body, and the main function of this agency is a registration, examination of intellectual property objects like the trademarks, patents, industrial designs, geographical indications, and copyrights, related rights. Insurance of the protection documents, certificate of registrations, patents, license, and other documents confirming the rights. Maintains of the register of intellectual property object. And one of the functions is international cooperation, representation before the World International Patent Organization, participation in international systems, PCT, Madrid system, Hague system, etc. Development and implementation of the state policy in the field of IP, including the protection of the right holders' interests, enforcement of IP legislation, and raising legal awareness in the field of the IP. And the last function is the support of innovation and creative economy. Talking about the IP law and the IP protection, we should talk about the patent attorney, because all operations involving intellectual properties objects in Azerbaijan must be conducted by the foreign person through the registered patent attorney. So the foreign, as I said, the foreign persons can't act independently and directly. They should apply to the patent attorney. And the patent attorney in Azerbaijan is a person authorized to provide professional service for the protection of intellectual property right, including the invention, trademarks, industrial designs, etc., on behalf of the domestic and foreign applicants. If I'm not mistaken, in Finland, the same system works. working. In Azerbaijan, the activity of patent attorney are regulated by the regulation of the patent attorneys adopted by the Intellectual Property Agency of Republic of Azerbaijan, and main functions of the patent attorney is preparing and filing applications for inventions, utility models, industrial design, and other object of copyright of the IP law. Managing the application related the proceedings before the Intellectual Property Agency, conducted correspondence with the state authorities on behalf of the applicant, challenging the examination decision and filing the oppositions and appeals with the appeal board of the agency, and provide legal support in disputes concerning the intellectual property rights violations. Just for information, the candidate to the patent attorney must be the only citizen of Azerbaijan Republic, holds a higher education degree, preferably in technical and legal field, has a practical experience in the field of intellectual property, pass the qualification examination administered by the Intellectual Property Agency, and finally be registered in the official register of the patent attorneys. The official website of the Azerbaijan Intellectual Property Agency provides a list of the accredited patent attorney, including their contact information and area of specialization. So if you have if you need any information, or you need to contact with any patent attorney, local patent attorney, you may apply to the website and find the relevant partner in these procedures. The next one is the trademark registration process. The trademark registration process in Azerbaijan is governed by the law of trademark and geographical indication, as well as civil code. The primary authorized body is the Intellectual Property Agency of Azerbaijan Republic. The registration process consists of the following stages. As you see on the slide, it's identity of similar search, the filing application, formal examination, substantive examination, publication in the official bulletin, and registration finally in the issuance of the certificate. First stage, it's a identity and similarity search. It's optional but recommended because the process of registration is very long term, and so we should realize and understand that we're on the right way when we start of registration. So in this stage, we should search the database of registered trademarks to access the chance of successful registration. The search is conducted by the applicant either independently through the patent of attorney. The patent attorney is may help you in the first stage to define of chance and whether it's a success process or not, because they have how to say the instruments and tools and relationships with the register, and they define is this trademark registration successful or not on the initial stages. And the official part started with the filling application of the application. The application for the trademark registration must be submitted in writing or electronically to the registering authority. The applicant can submit the document directly. In your case, it's only via through the patent of attorney. The application and the attached documents must relate only one trademark. The application for the trademark registration must include the following information: application's name, address, and signature. If it's submitted by the patent attorney, their names, addresses, and signatures. Representation or 3D form of trademark, a list of goods and services grouped according to their needs classifications. As I said before, this classification consists of around 45 classes. So the next one, the color and of the trademark is applicable, and transcriptions and translation of the trademark or part of it. The application must be signed either by the applicant or an asserted representative. When we apply, we pass to the next stage is a formal examination. The correctness of the application and presence of all required documents will be checked in this stage. If the application passes the check, the final date is assigned, and the primary examination of the trademark application documents for the compliance with the filing requirements is completed within approximately 1 month of receipt. And during this stage, the content of the application, the required documents, and their compliance with the established requirements are reviewed. Based on the result, the applicant is informed about the acceptance of the application or its rejection. The next stage is a substantive examination. It will lead more than initial examination, and consists of the trademark is examined whether there are any conflicts with the previously registered trademarks, complies with the legal requirements, for example, no misleading elements. The examination may be resolved in either a refusal or request for additional materials. The substantive examination of the trademark is carrying out approximately within 6 months from the completion of the normal formal for the examination. During the stage of distinguishing these conflicts and with the earlier registered marks and legal compliance of the trademark are reviewed. Based on the result of this examination, the reasoned decision is made regarding the registration or refusal of the trademark. The decision is communicated to the applicant within 10 days. And if we pass the substantive examination, we enter to the next stage, and I think the final stage is the registration and publication in the official bulletin. So after the successful examination, the application is published. The third part may, in this period, the third parties may file the objections within the 3 months. The registering authority will, based on the examination decision, register the trademark in the state register of the trademarks within the 1 month. The register includes the trademarks, image, information about the priority, the owner's details, and the registration date, and the list of goods and services grouped according to the needs classification. Additionally, the register includes information about the trademark registration, renewal, cancellation, and any subsequent exchange. For the collective trademarks, information about this and entitled to use the trademark is included too. After the payment of the fee, the registering authority issues the extract from the register. The details from the register may be published in the official bulletin issued by the relevant executive authority. In the absence of the objections and after the rejections of registration occurs, the applicant issued a trademark registration certificate. The registering authority issued registration as a certificate for the trademark, which is valid within the territory of the Azerbaijan Republic. This certificate confirms that the trademark's registration is priority the owner's exclusive rights concerning the goods and services and includes a description of the trademark. The certificate is issued within 1 month from the registration date. I should note that through the Madrid protocol system, Azerbaijan can be designed in an international application too. As I know, in Finland, the procedure is the same. It's very similar, and it leads about 1.5 year. So we may say that it's very closely, very how to say, similar with the Azerbaijan system of registration. Sorry. Okay, let's talk about the. If you have any questions regarding the registration process, please send the questions or apply. If not, I just continue, and we talk about the refusal of registration because it's very important. If you have a long-term process, you should know the grounds of refusal, of course. The following trademarks will not be registered. Trademarks that do not meet the definition of trademark under the trademark law. Trademarks that are not distinguishable from the other marks that do not differ in essential elements. Trademarks that describe the nature, quality, quantity, purpose, price, origin, or other characteristic of the goods and services. Trademarks that include geographical indication not corresponding to the true original of the goods, but which may be associated with them. Marks that reflected the essence of the goods essential for technical purposes or provide significant value. Marks that contain elements while violating public order, morality, harming the personal reputation. Marks that include the religious or state symbols. And marks that consist of expressions contrary or to the public order, such as the name of the famous individuals or well-known literature works without consent. If the applicant disagree with the decision regarding their trademark application, they may appeal within 3 months from the date of receipt of the decision. Yes, the appeal will be reviewed by the appeal board within 3 months. The applicant or patent attorney has the right to participate in the appeal hearing and examine the material of the decision. The applicant may challenge the decision of the appeal board in court within 3 months from the date of receiving the decision. So the next slide is about the exclusive rights to a trademark. So during the validity period of the trademark, its owner holds the exclusive rights to use and dispose of the trademark within the territory of the Republic of Azerbaijan. The owner of the registered trademark has the exclusive rights to prevent third parties from the using in the course of trade without owner consent. And identical and or similar trademarks on or sign for the goods services that are identical or similar to those covered by the owner's its trademark if such use is likely to cause confusion. The likelihood of confusion is deemed to exist when the identical sign is used in relation to the identical goods and services. The person who holding the rights to the trademarks may not be prohibited to use of the trademark in relation or to goods that have been lawfully put on the market in Azerbaijan by the right holders or with their consent. If the owner of trademark in one of the member countries of the Paris Convention for the Protection of Industrial Property does not authorize its use by their representative or agent in the Republic of Azerbaijan, in accordance with the Article 6 of the Convention, they have the right to oppose such unauthorized use. The owner of well-known trademark may demand the prohibition of any trademark that consists of the reproduction, imitation, transliteration, or translation of that well-known mark and creates a false association with it, especially where such trademark is used for identical or similar goods or services. The owner of the registered trademark may also demand prohibition of trademarks that creates and false association, even if the good or services in question are not intentional or similar. And the exclusive rights do not extend of those elements of trademark that cannot be registered as trademarks in their own rights. Use of the trademark is generally deemed to occur when it appears on the goods or their packing in relation to the provision of services, in advertisements, in printed materials, on signage, in exhibition or trade fair displays held in Azerbaijan Republic, and other documents related to the marketing of goods. Trademark use also manufacturing goods, storing them in the warehouse, offering them for sale, placing them on the market, and importing and exporting the goods. Offering goods for sales, selling goods, and providing services under the trademark constitutes evidence of the use of the registered trademarks. Legal and natural person engaged in intermediary activities on the basis of mutual contracts may, alongside the manufacturers or services providers trademark, also use their own trademarks. Owner of the collective marks may use both of collective mark and their own individual trademarks in relation to the relevant goods and services. And one of the important point of the registration and protection of the trademark is a term and renewal of the trademark registration. So trademark registration is valid for 10 years from the date of application is filed with the registration authority. At the request of the trademark owner, and upon the payment of the prescribed fee, the registration may be renewed for successive 10 years period without limitation. After the expiration of the registration term, the trademark owner is granted a 6-month grace period subject to payment of the additional fee. Information regarding the renewal of the trademark registration is entered into the state register, reflected on the certificate, and published in the official bulletin. Okay, the next topic is registration or patent registration process. It consists of the application preparation, formal examination, preliminary examination, and substantive examination, and decision and publication. It's very similar with the trademark process, registration process, but the more, how to say, it's more complicated, I think. So the first stage is application preparation. An application must include a request of the grant of the patent, a description of the invention, disclosing the essence, technical backgrounds, and objective, claims clearly defining the scope of protection, drawings, if it's applicable, an abstract, proof of payment of the prescribed fee. Translation is in Azerbaijani is mandatory for all documents submitted in foreign languages. For example, our patent attorney have a cooperation with the professional translators who deal with only patent and trademark registration documents translation. Both natural, personal, and legal entities seeking patent protection for invention, utility models, or industrial design shall submit an application to the registration authority. The applicant may submit the application either directly or through a patent attorney registered in the official register. The authority of the patent attorney must be certified by the power of attorney issued by the applicant. An application for the invention shall relate to one invention or a group of inventions that are united by the single general inventive concept. The application must contain a request for the grant of the patent, including the name of the inventors and the natural or legal person in whose name the patent is sought, as well as their addresses. The description of the invention, disclosing it in a manner successfully clear and complete for it to be carried out by the person skilled in the art. Claims based on the description defines the subject matter for which the protection is sought, and the drawing and other materials essential for the understanding of the invention, and the final, the abstract. An application for the industrial design must be related to the single design if multiple items together form a single artistic and structural composition, they are considered one design. Similarly, if several designs fall within the same classification, they may be treated as a single application. The application for the industrial for an industrial design must include a request for the grant of the patent indicated of the name also of applicants along with their place of residence or businesses. A set of photographs and models or a drawing giving the clear description and of the external appearance of the product. general design, drawing the ergonomic diagrams or construction maps if necessary for the disclosing the essence of the design. The description of the essential features on the industrial design. The request for the patent must be submitted in Azerbaijani, as I said before. As applications, materials may be initially be submitted in Azerbaijani or another language, but any documents in foreign languages must be translated in Azerbaijani within 2 months from the filing date. All proceedings related to the application are conducted in Azerbaijani. The applicant is entitled to make amendments and additional to the application within 1 month from the filing date, provided they do not alter of essence of the claimed invention unity model of industrial design. Amendments may also be submitted after the 1 month period before the publication decision is made via the formal request. Amendments proposed by the examiner may also be incorporated. However, the additional materials that alter of the claimed subject matter or introduce future or disclosing in the original filing shall not be considered part and may only be submitted by a separate application. The next stage is the formal examination. During the formal examination, it accesses the completeness for formal compliance of the documentation, presence of all required components of the application. If complaint, the application proceeds to the preliminary examination. If insufficient, the applicant is given the deadline for the correct deficiencies. The next stage is it's a preliminary examination. It leads approximately 3 or 6 months. During the preliminary examination, it assesses patentable subject matter, priority and filing date, novelty, obviousness, and within the Azerbaijan Republic. Upon the success review, the applicant may request the substantive examination. So the substantive examination is the longest part of the registration process, up to 18 months. The applicant must request to the substantive examination within 3 years from the filing date. The assesses global novelty, inventable steps, and industrial applicability. The registration authority performs the patent search and analysis international databases. The authority also verifies the compliance with the inventions, compliance of the invention with the novelty requirements applicable in the Azerbaijan and other relevant regulations for protection documents enforceable in the Azerbaijan Republic. Upon the request from the applicant or another interested party, the registration authority conducts the patentability search and substantive examination within 18 months from the filing date. The result of the is communicated to the applicant or the requested party. And the last stage is a decision and publication. If the application successfully passed the examination and decision is made to grant a patent. Publication of the application details in official bulletin includes the author information, applicant information, title of the invention or design, international patent classification, it's IPC code, international classification of industrial design, if registers a design, industrial design, priority date, abstract and invention of the utility model, if we register the utility model, of course, and list of a list and description of the essential features of the industrial design. If the application is found to comply with the legal requirements, it's published in official bulletin. Otherwise, a decision to refuse the patent is issued. The claimed invention must be extended beyond the content on initially filed application and must be clearly identified as an integral part of thereof. An applicant may appeal a decision of refusal to the appeal board of the relevant executive authority within 2 months of receiving the decision. The applicant is entitled to review all materials related to the appeal board's decision. Okay, let's talk about the duration of the legal protection granted by the patent in Azerbaijan. The term of the legal protection provided by the patent in Azerbaijan Republic is calculated from the date of filing of the application with the registration authority and is followed as 20 years for inventions, 10 years for the utility models, and 10 years for industrial design. If the subject of the matter of the invention concerns a product or method of manufacturing a product that is subject of administrative approval procedures in accordance with the regulations established by the registration authority, the term of the patent may be extended up to the 5 additional years upon the request of the patent holder. The request of the extension must be filed within the term of the patent industrial design. Within the patent, sorry. The term of protection may be extended for the industrial design. The term of protection may be extended for up to 5 additional years upon the request of the patent holders. The patent rights granted for the method of manufacturing product extends directly or any product obtained through the use of this method. A new product is presumed to have been produced using the patented method of absence of the evidence to the contrary. Regarding the copyright protection in Azerbaijan, copyright arises upon the creation of the work and remains in the force for the lifetime of the author and for the 7 years after their death. Moral rights of author, such as the right of authorship, name, integrity of the work, etc., are protected without time limitation. Upon the author death, economic rights pass to the heirs under the statutory inheritance rules or by will. Moral rights do not pass to by the inheritance. However, heirs have a right to enforce and protect the author's moral rights, and this right is not limited in the time. The author may design a specific person, similar as to the appointment of the executor of the will to ensure the protection of their moral rights after death. Such person exercises this power for life. In the absence of such designation, Moral rights are protected after the author's death by the heirs or the registration authority if the author has no heirs or if their rights have been expired. For the works published anonymously or under the pseudonym, copyright lasts 7 years from the date of lawful publication. For joint works, copyright is valid for the life of all co-authors and 7 years after the death of the last surviving co-author. For the copyrights holders, as well as the collective management organizations, have a right to demand cessation of any acts of infringe or post the threat of copyright to related rights. The pirated copies are considered any copies of the work phonograms produced by distribution in violation of copyright in related rights. Copies of the works or phonograms imported in Azerbaijan without any consent of the rights holder from the countries where these works, its phonograms were never protected or the protection has expired. Okay, let's start the next topic. It's about the protection of confidential information in transaction in Azerbaijan. The protection of the confidential information is a fundamental component of the legal security in a business, particularly during the negotiations, partnerships, contract execution, technology development, and other commercial activities. In Azerbaijan, the regulation of confidentiality is governed both by the civil and labor law provisions and contractual practice. A key piece of the legal legislation is the law of the Republic of Azerbaijan on commercial secret, which defines the concept and legal regime of the commercial secrecy. Okay. Under the Azerbaijani law, commercial secret refers to the information related to the production, technological, managerial, financial, and other activities of the legal and natural persons, the unauthorized disclosure of which may cause harm to the lawful interests of the information holders. To qualify as a commercial secret information must meet the following conditions. As you see on the slide, it's a three condition. It's a commercial value, protective measure, and lawful restrictions on accesses. So regarding the commercial value, the information must have commercial value due to its not public nature, giving its holder a competitive advantage. It may be sold, transferred, donated, licensed, and inherited in whole or in part. The protective measures means that the owner must take legal, organizational, and technical or other steps to the prevent of confidentiality of the information. And law restrictions on access, it means that the information must not be freely accessible to the public by the lawful means. In addition to the statutory confidentiality regime, contractual arrangements play a vital role in the business practice. Parties to the business relationship may agree to specific terms regarding the confidentiality by entering into the non-disclosure agreement or confidentiality agreement. Is the same name of the one document, which defines the scope, duration, permitted disclosures, liability of the breach for the breach, and dispute or resolution mechanism. Such agreements are legally binding and enforceable under the Azerbaijan law, provided they meet general contract validity requirements under the Civil Code of Azerbaijan Republic. In conclusion, the dual framework of statutory and contractual regulation ensure the robust legal protection of the confidential business information in Azerbaijan. In Azerbaijan, non-disclosure agreement or NDA serves as a contractual instrument for the legal protection of the confidential information exchanged between the parties involved in negotiations, joint ventures, partnerships, and employment relationships. And non-disclosure agreement may the form of the standalone agreement executed independently between the parties. The confidentiality clause integrated into the broader counter supply, franchise, service, or other kind of contracts of agreements, and in the form of annex to the employment agreement, especially addressed confidentiality obligation of the employees. NDAs are widely used in following scenarios. For example, pre-contractual negotiations concerning potential cooperation or transactions. The next one, the joint development of product, service, or technologies. Next, the outsourcing arrangements, including the engagement of the external consultants or advisors. Employment relationships and engagement as the freelancers or contractors who have access to the internal business information, and the transfer of the proprietary know-how, business models, algorithms, technological processes, and other trade secrets. NDA are fully enforceable under the Azerbaijan contract law, provided they comply with the general principle of Civil Code of Azerbaijan Republic, including the consent, legal purposes, and capability of the parties. They allow the businesses to define the scope of confidential information, specify the duration of confidentiality applications, impose the restrictions on the disclosure and use, and establish the liability and remedies for the breach, including the inductive relief or damages. So, NDA in Azerbaijan are recognized and essential legal mechanism for the safeguarding sensitive business information, helping to mitigate risks associated with the unauthorized disclosure or misuse of properly data and proper drafting and integration of the NDAs into the business practices of critical ensure their effectiveness and enforceability. So in this slide, you may see the basic elements, and it's of the non-disclosure agreement. So here's a typical structure of the non-disclosure agreement under the Azerbaijani law, outlining the key elements generally included to ensure legal enforceability and clarity between the parties. So you can see the elements. First of them, the definition of the confidential information. It specifies that constitutes confidential information, such as the business data, technologies, financial and strategic documentation, database, etc. The purpose of disclosure is to clarify the reason for disclosing of information. For example, to assess the feasibility of the business cooperation or potential partnership. Obligation of the parties, the next element, it typically includes not to disclose third parties, not to use information beyond the agreed purpose, not to copy or transfer, etc. Term of the agreement is a very important clause too, and the NDA remains in the effect during the cooperation period of the set period, thereafter usually 2 or 5 years after termination of relationships. But the term is optional, and it depends on the mutual consent of the parties. And exclusions is a common exceptions include the information already in public domain, information lawfully obtained from the third parties, disclosure required by law. And liability of breach is the next element. It may include compensation of damages, contractual penalties, executive relief, or other judicial remedies under the Azerbaijan law. And the return of the destruction of the information defines how and when confidential materials must be returned or destroyed after the NDA expires or is terminated. And the last one, last element, government law and jurisdictional, it's an element of all contracts as well as an element of the NDA. Usually governed by the law of Azerbaijan Republic, with dispute resolving the court of the city of Baku or the court of Azerbaijan, unless otherwise agreed. This structure reflects best practice for ensuring that the NDA is a clear, balanced, and enforceable under the Azerbaijani legislation, particularly the civil code and law on the commercial secret. Proper legal drafting is essential to avoid ambiguity and to ensure the protection in case of disputes. For more effective drafting and implementation of the NDA under the Azerbaijan law, the following practice is recommended. First, the clearly defines that constitutes confidential information. Avoid the vague or overly broad definitions, especially exact categories such as technical data, business plans, client lists, financial models, etc. Limit to access to the confidential information. Ensure that only employees or third parties who have signed confidentiality undertaken and are permitted access to the sensitive data. Include penalty or compensation clause. In the event of the breach, define the specific consequences such as liquidated damages or reimbursement for the loss incurred. The next one is they execute the NDA before any disclosure takes place. Do not share sensitive information until the NDA is signed by all related parties. Post-disclosure NDA may be lacking enforceability. Maintain the integral registry of the signed NDAs, keeping organized records of all executed NDAs is sound compliance and risk management practice, especially for audits, dispute resolutions, and contract enforcement. These measures help to ensure that NDAs are not only legally valid but also practically effective in protecting the confidential information in commercial transactions and professional relationships in Azerbaijan. So the NDA is not only a tool for the protection of the information. So we need the technical protection measures like that. Restricted access need to know basis. Limited access to the confidential information strictly to those employers or contractors whose role especially require it. Electronic security implements the encryption, password protected file and system of and logging of all access events to track or who accessed what and when. And data transfer controls introduce restrictions on copyright, downloading and transmitting sensitive data, such as disable USB ports, limited printed access, or using the secure filing transfer system. And the next measures is internal policy documentations. Internal policy on trade secrets adopt and communicated a formal internal regulation defining what constitutes trade secrets, how they are to be handled, and by whom. Access and handling protocols created clear procedures governing how confidential information is accessed, transmitted, stored, or disposed of. And employee non-disclosure commitments requires the employee, including the contractor and consultants, to sign internal non-disclosure undertakings, ideally as a part of their employment or service agreement. These organizational and technical measures, when combined with a well-drafted NDA, significantly strengthen the enforceability of confidentiality obligation under the Azerbaijani law, and reduce the risk of the unauthorized disclosure. If you have not any comments or questions regarding the previous information, let's talk about the license agreement. As you see on the slide, the license agreement is a contractual arrangement whereby the rights holder, the licensor, grants another party, licensee, the rights to use the object of intellectual property under the specified conditions without transferring ownership rights. So this type of agreement is applicable to trademarks, patents, utility models, industrial designs, copyrights and related rights, and of course know-how as a form of the trade secret. The owner of the trade secret, the owner of the trademark may assign to another person the right to use the trademarks under the license agreement, either in relation to all goods or services covered by the trademark or portion of the roof. License agreement concerning the use of the trademark must be registered with the authority designed by the competent executive body, subject of the payment of the fee, and the registration becomes effective only upon the payment of the state duty and the publication of the agreement on the official bulletin of the registering authority. Only Only after such registration does the license agreement occur legal effects in respect of the third parties and may be enforced against infringing acts by others. In Azerbaijan, as in most legal systems, several types of intellectual property license exists, differentiated by the scope of rights granted, the number of permitted users, and the legal status of the parties involved. This license are governed by the Civil Code of Azerbaijan Republic, as well as the specialized laws on patents, trademarks, copyrights, and related rights. On the slide, you can see the main type of the IP license. So first of them is an exclusive license, which grants the license exclusive rights to use the IP object. The right holder is excluded from the using of the IP themselves. Non-exclusive license, the licensee is allowed to use IP, but the right holder retains the usage rights and may grant license to others. Sub-license is a license transfer to the licensed rights to the third party, provided that such transfer is expressly permitted in the original license agreement. Simple license is a variation of a non-exclusive license, typically used in copyright agreements, where the license lacks exclusivity but may use the work within agreed boundaries. And the last one is very interesting: the compulsory license granted by the court or competent authority if the rights holders and justifiable economic fails to use IP, thereby hindering market access or economic development. This license is always non-exclusive. The compulsory license may be issued with respect to a patent if the patent owner or their successor fails to use the invention and make serious preparation for its use within 3 years of the patent grant. So if you register your patent, you should actively use it or to do something which express your intention to use it. The use is suspended for more than 3 consecutive years without justifiable reason, and the right holder refuses the grant license after the period. In such cases, any interested person, legal or natural, may petition to the court to obtain the compulsory license for the use of the invention. If the license fails to use, the compulsory license within 2 years is its issues. The patent holder has the right to request its cancellation in the court or in accordance with the procedures established by the competent executive authority. A registered trademark may be revoked by the appeal board of the relevant registration authority if the trademark is not used continuously for the 5 years from the date of registration, or it's not used for 5 years presenting the filing or not use claim by any interested party. This compulsory licenses and revocable for non-use are regulatory tools aimed at ensuring the active and fair use of IP rights in Azerbaijan market. So in the next slide, you can see essential and key terms of the IP license agreement. So the first one, as usual, is the subject of agreement. We should clearly identify of the IP object, patent, trademark, with a number of registration and other details of the object of the contract. We should define the type of license, whether the license of exclusive or non-exclusive sub-licensing rights or if permitted. The next one, the territory. It's very important because you should define the territory where the rights is grants. Term of agreement fixes the term for the duration of the IP rights, for example, 5 years until patent expire and other conditions. Permitted use, what rights are granted? Reproduction, sales, distribution, importation, advertising, sub-licensing, or others. Of course, remuneration or royalties as the method of payment, lump sum, percentage of sales, milestone-based payments, etc. Monitoring and reporting, how the licensor will monitor usage, reporting the frequency or format. Liability for breach is a penalty, damage, and early termination provisions. Confidentiality, of course, the prohibition of the disclosing technical or commercial details related to the IP. Restrictions to on transfer. The next one, whether the licensee can transfer rights to the third parties, special supplies and conditions. Registration requirements in this industrial property license must be registered with a special authority body. Termination for the provisions. Early termination conditions, but by mutual consent for breach of clauses or the force majeure conditions. Government law and jurisdictional, typically Azerbaijani law or local law courts, but it's how to say it's defined by the mutual consent of the parties. And the last one is a notice of and correspondence. Party contact details and acceptable meaning the communication, email, courier, post, and other. It may be any optional special clauses in license agreement, depending on the commercial intents and negotiations. The following may be included too: the application to use the license object within the specified period, automatic renewal agreement upon the expiration, non-competitive clauses prohibiting the licensee from engaging in competing activities, minimum performance obligations such as the minimum sales of end user the end use, quality standards, compliance obligations, especially important in the trademark license. In practice, a well-drafted IP license agreement under Azerbaijani law not only protects the interests of the both party, but also ensures that the IP assets is used legally and effectively, especially when it involves registration-dependent rights, such as a patent and trademarks. So the last part of our webinar today, it's the enforcement mechanisms for the protections. IP law, law objects protections. We may divide it into the two parts: in the administrative enforcement and litigation protection by the court. So the first one, the administrative enforcement. The Appeal Board of Intellectual Property Agency of Azerbaijan Republic is specialized in quasi-juridical body operating under the Intellectual Property Agency. It is vested with the authority to review disputes on complaints arising in the area of registration and protection of the intellectual property rights. Importantly, the Appeal Board does not adjudicate all IP-related disputes, but rather focuses on the specific category of administrative and registration-related matters. The Appeal Board considers the following type of cases. First, the complaints against the decision and actions and inaction of the registration authority, including the refusal to register or a patent, trademark, or industrial design, decisions or to terminate registration, refusal to extend the duration of the IP protection. The second one the second type of case is a dispute concerning the application examination, such as objections to the result of a formal or substantive qualified examinations, contested the findings regarding the novelty, inventive step, or originality. The third type of cases is oppositions to the registration of IP objects, including the claims that the proposed trademark infringed prior rights and of the third party, disputes over the similarity to a degree of confusion with the previously registered marks. The next one, the petition or to invalidate a registration in case where the object was registered in a violation of the law. There is evidence of the bad faith registration. And the last one is complaints concerning the decision on the international applications under the Madrid system and PCT, etc. Particularly in case where the refusal related to international trademarks and or patent application. It's important to note that the Appeal Board is not judicial body, but rather than administrative forum intended to resolve certain disputes prior to the judicial proceedings. However, decision of the Appeal Board may be further appealed in court if the party is not agree with the outcome. This structure offers an administrative layer of legal remedy within the IP system of the Azerbaijan, which serves to ensure the procedural fairness and legal overrides before the resorting to the litigation. So the next mechanism of the IP protection, it's of course a civil litigation. How to say this? A last instance of protection. Judicial protection of intellectual property rights in Azerbaijan Republic serves as a key legal mechanism that enable the rights holders to halt infringement, seeks damages, and restores their violate rights. This protection extends to all categories of IP objects, including the trademarks, patents, copyrights, and trade secrets. To file an effective legal claim, the IP rights holder must be prepared to present following: documents confirming the registration of IP rights, such as the certificate, patents, and etc. Evidence of infringement, which may include photographs, videos, websites, screenshots, receipts, or reports from the private investigators. And financial calculation of damages, where the compensation is being claimed, and correspondence with the infringers, such as a pre-litigation case and deceased letters, and any responses. This structured approach enhances and enforceability of IP rights and support for the legal standing of the claimant in court proceedings. So it's all what I want to talk about today. We have finished our webinar, and if you have any questions, any recommendation, maybe, I was happy to see.
Thank you, Emil, very much for this deep dive. This was actually a really deep dive, and there are a lot of details and terms and things you will have to know. So thank you very much for this. This was really excellent. Then questions.
I just want to note one point, that that the system of protection in Azerbaijan, like in Europe, like in the worldwide, I would say, mechanisms of protection, we have a similar, because we integrated to the international treaties, and we have an obligation to protect IP objects, not in local people, for local people, but the foreign people and foreign entities too. So you may be sure that if you have any activity in Azerbaijan, and we do all procedures, relevant procedures in accordance to the law, so we are saved. That's what I want to say at the end. And if you have any question now, I'm very happy to see it. If not, the organizers may send my emails and you may send there any questions, maybe suggestions, maybe any how to say, requests for the detailization for some points, maybe. And I'm happy to answer, to reply all your requests.
Excellent. Actually, I have two questions by myself. It was in your presentation that all IP operations must be conducted by registered patent attorney. So where can you find such attorney? Are those listed or somewhere, or is it just that you will have to find or ask some law office, or how those are, how those can be found?
Okay, thank you for your quick questions. Yes, the foreign entities and individuals, foreign individuals, should apply for the registration via the registered patent attorney. It's we may see the limited list of the registered power of attorney who may contact with you and help you with the registration in the official website of the agency. You may see the website agency on one of my slides of this presentation, and yes. And yes, you may click and find the list of this with the detailed information regarding the specialization, the numbers and addresses of the person who deal with this. The patent attorney is a very separate caste of the specialist. It's not only lawyers, it's definitely specialized in the IP law and IP procedures in Azerbaijan and worldwide. So take in consideration that most documents should be translated to in Azerbaijani, and we have any special peculiarity of the local processes of registration, you need such specialists. I think in practice, we all, even me, apply to the patent attorney because part of my, I'm a lawyer and I'm a legal advisor. Sometimes when the clients apply to me with such issues, I just prepare the initial part of my documentation, then I pass most of the functions to the patent attorney because it's our rules.
Yeah, thank you, Emil. Did you mean that the list can be found from the was it this COPAT, Republic of Azerbaijan Intellectual Property Agency?
Yeah.
So yeah, the website I just copied that and sent it to them as a message. And just like you mentioned that all documents and application must be in Azerbaijan language, so it requires quite a lot and reliable relationship with the attorney. Yeah.
Yes, and it's a very special translation because it's related to the inventions or trademarks. It's very peculiar, special texts, and it should be translated properly. So we can't use the service of the ordinary translators, and we trust to the list of the translator, which works with and cooperate with the patent attorney who deal with the special texts.
Yeah.
And special documents. If you can't find now the list of the patent attorney's list, I can provide it later if you need it.
Yeah, that would be nice. Thanks. Yeah, and of course in the future we will share your email address just like agreed. So if there are needs, so they can also contact you, and if they have questions, and you may direct, and or maybe also serve some services if needed. Yes, thank you very much. Does anyone else have any questions? If not, then we can end this webinar, and we will also end the recording, and we will share the recording in our project website. I just send that address also in the message, so you can find it from there after a couple of days, I would say, and you can also find additional information about our project from that website, and there's also contact information for our Satakunta University of Applied Science and also Estonian Latvian Chamber of Commerce. So if you are interested in the project or you have any questions, so please contact us. And at this moment, I thank you all who participated, and especially Emil for these excellent webinars you have provided. This is really deep information and detailed, so we really appreciate that.
Thank you very much.
And hopefully we will see next autumn when we are traveling to Azerbaijan again during our next great mission.
See you.
Okay, but thank you for everyone, and I hope everyone relaxing and warm summer. Hopefully the weather is going to better, but this webinar is so ended, and thank you for everyone.
Thank you very much.
Thank you. Bye-bye.
Bye.